This is perhaps one of the worst kind of tragedies, because at first blush, this does look like an operating while impaired type of case. Ms. Mitchell did admit to, and it was detected in her system to have alcohol when she was 19 years old. And she did have in her system chemical components of THC, marijuana. But as the state indicated, this was not enough in her system for the alcohol under 0.02 or the chemical components of THC to impair her driving. So this has to be looked at differently. Although it was a choice to have any sips of alcohol while under the age of 21, and it was a choice to consume THC at whatever level, at whatever time. And as I've read in the PSI document, it was an understanding of Ms. Mitchell that with regards to THC, that sometimes people think that THC is a medicine, and that in some cultures, it is not looked upon as a drug or an illegal substance. But it is. Whether it's used in ceremonies or culture is one thing, but in the state of Wisconsin, any detectable amount of an illegally controlled substance, including THC, while operating a motor vehicle is a crime. Whether or not it did impair Ms. Mitchell's driving, it was in her system and it is illegal. Whether or not the alcohol in her system impaired her driving, she was not of age to consume any. And now we have the death of a very beautiful young woman who will never be able to marry, who will never be able to be a mother, who will never be able to achieve the accomplishments that she could and be who she was to be. But we have her memory, and we cannot let that be soured. We cannot forget the tragedy. When a court sentences an individual for crimes, there are certain things that I have to look at. Both attorneys address them in general. The court has to look at how serious is this matter, the nature and the gravity of the offense. Everybody agrees this is extremely serious. A life was lost. Whether it's from any consumption of alcohol or THC, or here we have distracted driving, cell phones. Every person who is behind a wheel, a vehicle should note that and should not allow that person to be able to view or see texts or messaging or anything of that nature. Some people even say telephone calls. I'm sure everyone in this room has an understanding of what a cell phone does and how it distracts a driver. And we have a night where there was weather issues. We have extreme speed, 80 to 81 miles per hour. We have Ms. Mitchell driving a vehicle that she was not familiar with. We have Ms. Mitchell driving without a driver's license, without ever having went through and completing a driver safety course and taking the exams to be licensed. Multiple things here, multiple things that are adding up. They are choices. Every one of these was a choice. This was an accident, but it was an accident that could have been avoided. Second, the court has to look at the defendant and her character, her past criminal record, and look at her rehabilitative needs. We have lost a life, but does the court look at losing or significantly harming another life? And now we have a baby involved that was conceived after this incident. Whether the baby was an unexpected blessed accident or unplanned pregnancy, whether the baby was planned, and if so, that in it of itself is selfish. Or was the baby planned not only to perhaps take away the pain of Miss Mitchell that she is feeling from the accident, the guilt that she is feeling from the accident, but the court has to look, was this baby conceived to try and avoid punishment? The baby is also a victim. Because no matter what the court does, he did not choose and he did not do anything to be responsible. The third thing the court has to consider is the need to protect the public. And here this is partly about the victims and their feelings and their emotion and their tragic loss. But it is also largely about the rest of us, the community, the people who live in this community and in this state. And in looking at the public, I have to look at one of the factors that Mr. Schmidt hit on, and it was echoed by Mr. Gondik: deterrence. Not only specific deterrence to specifically deter Ms. Mitchell from any further action or conduct like this, to deter her from continuing to make such negative and poor choices, but general deterrence so that the public can be deterred from similar type behavior. The court cannot determine if one of those factors and negative choices alone caused the accident, if it's a combination of all together, whether Ms. Mitchell herself is fully responsible, or whether the individual who grabbed the steering wheel and caused the vehicle to swerve and to lose control is partly to blame. We have lost a life that cannot be brought back, but there are lessons that can be learned to protect the public in the future. I have reviewed the pre-sentence investigation report very thoroughly. I've reviewed the alternate PSI. I have reviewed the character letters and the mental health professional assessments. I've heard the statement of the victims and that impact, as well as the impact on Ms. Mitchell. It's unfortunate, beyond unfortunate, this case. And it makes me recall, I believe it was 2015, the loss of the 3 Milltown Angels, those 3 little girls that died tragically in the vehicle when the mom/aunt was distracted by her telephone. 3 little girls died that day. Just as Katrina died this day. Ms. Mitchell is taking responsibility. She has pled guilty to a very serious crime. It will forever be on her record and in her past of homicide by a negligent operation of a vehicle. That will forever be part of her story. Now, what you do with that story, Ms. Mitchell, is completely in your hands. You can continue to better yourself. You can continue to be a better community member, a better Native American. You can continue to be a better mother, a better friend, a better auntie, a better person. Or you can totally throw it out the window, if not today, some day in the future, and sour the memory and loss of Katrina. This will forever be on your shoulders, and it is your choice every single day to continue to live and better Katrina's memory or to tarnish it. My higher courts have advised and directed me that I must first look at probation. Unless confinement is needed to protect the public from Ms. Mitchell and further criminal activity, unless she needs correctional treatment that she can only receive in an institution that she cannot receive in the public, or if probation would unduly depreciate the seriousness of the offense. And if I am to order confinement, either with probation or a straight incarceration sentence, I must order confinement at an amount as minimum as possible, which is consistent with the protection of the public, the gravity of this offense, and rehabilitative needs of Ms. Mitchell. I do applaud and commend Ms. Mitchell for the actions she's taken since the date of this incident to correct things in her life, to address her mental health, to address substance abuse issues, to understand consumption of alcohol and illegal substances, anything that can impair your ability to fully think properly or to operate heavy equipment or a vehicle. She has done many positive things since this date, October 4th, 2023. The court looks at those positive things that you have done, Ms. Mitchell, but I also need to look at the negative things that you did leading up to the loss of Katrina. Because this is about punishment as well. And it is about deterrence as well. And I do also have to take in your past and the traumas that you may have experienced and what may have led up to your choices that day. And you had a very unstable childhood. But again, you are in a place where you can take control of your choices, and you can direct and teach your child how to do better and to make those better choices so that he is not sitting in that seat in 18 years. I have many recommendations for sentences, and it is surprising that the alternate PSI actually recommends a higher sentence, higher punishment, both on the front end and on a back end if the court follows a recommendation of probation and if you are revoked. That was surprising.
All right, let's talk about that. Judge Mogen's sentencing in State of Wisconsin v. Eliza Mitchell was a masterclass in judicial balance firm where it needed to be, empathetic when it could be, and rooted in the law from start to finish. In delivering her final remarks, she didn't shy away from the emotional weight of the case, nor did she let it overwhelm the statutory framework guiding her decision. This wasn't just a sentencing, it was a reckoning with a loss that can't be reversed and a future that still hangs in the balance. The judge opened by laying bare the facts. Eliza Mitchell, 19 at the time of the crash, was speeding clocked at over 80 miles per hour in poor weather, in a borrowed vehicle she wasn't licensed to drive. She had THC and alcohol in her system, though neither met the threshold for impairment. But as Judge Mogen made clear, those substances were illegal for her to consume and compounded the recklessness of her actions. Every element that night was a choice. No license, no driver's education, a high-speed, distracted drive on icy roads with her phone out, all decisions that led to the tragic death of Katrina, a young woman with a bright future. Still, Judge Mogen didn't paint Mitchell as a villain. In fact, she acknowledged the steps Eliza had taken since the incident: sobriety, therapy, motherhood, gainful employment, and introspection. These were not small changes, they were life-altering efforts. The court applauded her for that, recognizing that Mitchell had made genuine progress and wasn't just play-acting for leniency. But the judge also asked a hard question: was Eliza's pregnancy, which occurred after the crash, an attempt to heal or a subconscious effort to avoid punishment? That question hung in the air as a reminder that even personal growth doesn't erase accountability. Judge Mogen made it clear this baby, too, is a victim of the circumstances, born into a story shaped by loss and recovery. In setting the sentence, the judge followed the legal roadmap. She considered probation first, as required, but recognized that any sentence had to reflect the seriousness of the offense, the need for public protection, and Mitchell's rehabilitative needs. She reiterated that this wasn't just about one poor choice, it was about a series of preventable decisions. And while Katrina's life cannot be restored, the goal now is to deter similar behavior in others and hold Eliza Mitchell to the promises she's made through her actions since the crash. Judge Mogen reminded Mitchell that this conviction will follow her forever. It's not a temporary phase or a passing hardship. It's part of her story, but what she does with that story is now in her hands. Will she continue to live in a way that honors Katrina's memory, or will she allow this chapter to define her in the worst way? The court's words were more than just procedural. They were a roadmap for redemption. It was a sentencing that understood pain on both sides and tried in its way to offer a path forward. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.